Bronkiewicz Law Firm. Your move.
In times of financial turbulence that we all pass through these days, one factor seems to be coming to the forefront radically. Cash flow is king no more. It rather seems to me to be the emperor, Shah, the king of kings. Chances are that in the next couple of weeks, you'll get an email from your contracting party telling you that they cannot afford to pay you, not because they are not being satisfied with what you deliver, but rather because they are not being paid by themselves. And this chain reaction can get very risky in business. Oh, you definitely do not want to participate in this domino effect. At the end of the day, it is a kind of a race. Creditors race for the prize, which is the debtor's estate. The question is, whose court executive officer will grab this estate first? And one factor needs to be recalled, is that some participants of this race do not play by the rules. They get illegal doping. Whom I think about is particularly tax office and social insurance authorities. They get huge legal privileges in Polish legal system. So it is up to us to try to outsmart them and do our share to be prepared to take our pole position in this race. Of many legal remedies available, two of them provide for particularly fast healing effects. I mean, acknowledgement of debt and enforcement order are the tools to help you get your money back. None of them require any court-involved activities, and both of them provide you for a significant shortcut to help you to get your assets reimbursed. I believe that you should be brutally honest when discussing with your contracting party why do you expect him/her to provide you with your letters. And if they want to play fair, they should have no problem with doing so, unless they want to abuse you. But if they agree, you get a very significant benefits. Please have a look at it. So if you manage to persuade your contracting party to provide you with acknowledgement of debt, the very first benefit that you obtain is interruption of the course of period of limitation, which is stipulated in Article 123 of Polish Civil Code. Please have a look. The course of period of limitation shall be interrupted by the acknowledgement of a claim by the person against whom the claim is made. To cut long story short, you simply buy yourself more time to pursue your claims in the future. But there's also one other benefit. So, if the situation comes down to the point when you have no other choice but to simply sue the party, you have, based on this acknowledgement of debt, you are entitled to get yourself an order for payment, which is stipulated in Article 485 of Polish Civil Proceedings Code. Please have a look. The court shall issue an order for payment if the facts justifying the claims pursued are proven by the following enclosed thereto. And in point 3, we have explicitly specified a call for payment and debtor's written acknowledgement of debt. What does it mean? It means that you have a very significant shortcut as far as the court proceedings is concerned, and particularly you save yourself quite a bit of money. Actually, these are not dollars; these are Polish zlotys. But you simply save for the expenses, for the court expenses. However, there is one drawback of this solution, because if you get an order for payment, the debtor can always object it. And that means that it puts you back on track for the regular, rather long court litigation. And this is when The third solution, the second solution, solution kicks in. So I believe that you should also try to persuade your partner to allow you to obtain from him enforcement order, which is stipulated in Article 777 of the Polish Civil Proceedings Code. And please have a look at the paragraph 1. The enforcement order is either of the following, and there you have point 5, which is a notary deed whereby the debtor submits the execution stipulating the obligation to pay a certain amount of money, either directly specified in the deed or expressed by means of valuation clause if the deed specifies the event conditioning performance of the obligation, as well as the time limit for the creditor to apply for a writ of execution for the deed. So that means also in some situations the section 4 can also be used. But in other words, that amounts to the fact that you do not have to pursue the whole court litigation. All you have to do is to get from the court the enforcement clause, which is like 3 days procedure, and it's that cheap, and straight away that means that your court execution officer can get to your creditor's estate at a really fast clip. So having this all said, please do consider trying to negotiate with your contracting party obtaining the aforementioned letters. Try to use them. I hope you might find them of help. Should you require any further assistance, should you have any questions, just drop me an email and I will be happy to be of help. Please also consider sharing, as I hope that this information might get useful for others. And certainly I look for any comments that you might have on my social media. Take care and all the best with your business. Bye bye.